Welcome to the 2012 Summit Podcast, presented to you by the Oregon Ministry Network. Summit took place May 14th through 16th at People's Church in Salem. The following learning lab entitled Church and Law, 5 Major Mistakes to Avoid, was taught by Ed Snook.
I want to first commend you folks for your ministries. Your ministries are far more important than legal issues. And the purpose here is to make certain that you are able to maintain your focus and to stay tuned to what the Lord has for you and your church or your ministry. And what I have to say, frankly, in my view, is trivial. That doesn't mean you can all leave. But it's trivial as compared to what you say in the pulpit on Sunday morning. But the purpose here is to make certain that you can keep that focus and to enhance your ministry. As Larry mentioned, I'm a AG pastor's kid who I'm not so sure they even had ordination back when he started. He got married in Yakima and then went around for the next 20 years planting new churches and having kids along the way. So I was born down up on the Columbia River in Bingen, white salmon, and we just would stay 3 or 4 years at one place and he'd go plant a church somewhere else. So he did that in Washington, and then of all places, he went to Michigan and did more of it there. So, but let me get started by making reference to one of the great philosophers of the 20th century. I thought I heard someone singing, "Bringing in the Sheaves." He rings the doorbell. "Hi, I'm from that new storefront church a few blocks up the street. Would you like to come to our church?" "I already have a church." "So we have good singing. So do we. Do you sing Blessed Assurance? Do you sing Sweet Hour of Prayer?" "We give our money in envelopes. Who cares?" "Oh, my dad is the preacher. Good for him. He says the world is coming to an end. I feel that way every time I get on the school bus. Anyway, you know where we are. I'm always here. These deep theological discussions wear me out." Well, we've got 3 basic objectives we want to run through, and I'm going to be doing this quickly. And your handout is exactly what you are seeing. I just copied them, and so you'd have them, but to understand basic legal principles applicable to church operations. 2, to recognize the legal risks that arise in ministry. And 3, identify risk prevention steps that minimize legal problems. As Boyd has already mentioned, we have seen in the last 20 years an literal explosion of litigation against pastors and churches. It's probably the fastest growth area for lawyers in the United States. And the obvious example of that is the Catholic Church. Every time you pick up the paper, you read another multiple $million settlement because of priest child abuse. That's the most common problem that we see today. But I want to tell you that virtually every single denomination has been hit with litigation. 15 years ago, 2% of churches were sued. Currently, it's 25 to 30%. So you can look around this room, and there's going to be 2 or 3 of you here that are churches that are going to be sued at one time or another. Claims short of lawsuit, 50% now of churches have had claims made against them that didn't get into litigation but in any event, the claims were made. Three primary reasons I'd suggest why we're seeing this explosion. Number one, you as pastors or ministry leaders have become, the business of the church and of your ministry has become increasingly complex. You are asked to be a CEO, a CFO, a business manager, an executive pastor, and in the large churches now, we have executive pastors who take care of these sort of things as their primary duty. The problem is that we haven't had good training to be a CEO or a CFO or a risk manager. And so that has caused, that's one of the causes for litigation on the increase. As Boyd has already mentioned, our society is becoming more litigious and less religious all the time. Churches have become targets. A few years ago, nobody would ever think of suing a church. I mean, it just didn't sound right. You wouldn't do it. But now, frankly, churches are targets. And there's a double-edged sword on that. A church now has to have liability insurance coverage. But if you do, and you do that to protect yourself, but if you do, you are more of a target. And so it's a two-edged sword. And by the way, as we go along here, if any of you have questions, feel free to jump in, get my attention, and we'll have a question and answer at any time you'd like to do that. You can do everything right in your church or in your ministry and still get sued. All it takes to get sued is $200 and an eager lawyer. That's all it takes. It doesn't have to have merit, and most of them don't. But again, all it takes is some filing fee money and a lawyer who is willing to take the case. And we now have a new meaning to shall we pray. This is now the current meaning in the litigation world of shall we pray, right here. And the other thing I would suggest is that the trouble with law is lawyers. Clarence Darrow, did you know that we have 94% of the world's litigation? We have 70% of the world's lawyers, and we have thousands of lawyers out there. All you have to do is get online and type in clergy malpractice, and up will pop hundreds and hundreds of websites where lawyers are advertising themselves as plaintiffs' experts in suing on the basis of clergy malpractice. Even the largest legal society in the United States, the American Bar Association, sponsors seminars on how to sue on the basis of clergy malpractice. A lawyer can go to seminars all over the country and attend these seminars. Well, here's a website that one of these typical websites, and this one is particularly interesting to me, and you probably can't read it, but it says U.S. Christian Legal Help Center, U.S. Clergy Malpractice Lawyer, connecting you with Christian lawyers. Okay? These guys are holding themselves out not only as malpractice lawyers, clergy malpractice lawyers, but Christian clergy malpractice lawyers. Hello, does that sound like there's something wrong with that picture? And then they have the nerve to stick John 3:16 on their website, and I've been trying to figure out for a long time what the connection is between John 3:16 and a clergy malpractice lawyer who's advertising on the web. And the only thing I can figure out is the whosoever will extend even to those guys. That's the only thing I can figure out in the connection there. Well, the bottom line here is this. A lawyer was asked to be a Jehovah's Witness. He said he hadn't seen the accident and had to decline, but he did offer to take the case. That's the bottom line of where we are in litigation against pastors and churches today. Lawyers who don't know much about anything, but are eager to take the case. Let me give you an example of the latest extreme litigation against churches and pastors, and I call it swoon and sue. There are probably a couple of dozen of these lawsuits around the country right now, but let me give you three examples: Illinois, Oregon, and Michigan. Oregon even got into the mix here on this one. Here's the first one. This is the Illinois bystander. Okay? Here's what happened. An Illinois woman claims she was injured during a church service when a parishioner was receiving the Spirit, fell backwards, knocking several other worshipers into her. Cheryl Jones' lawsuit describes a chain reaction of worshipers toppling like dominoes, caused, she says, by the failure of the Disciple Fellowship Christian Church of East St. Louis to provide ushers to catch the swooning practitioner. Typically, the suit says, 2 ushers would stand on each side of the church member to prevent the person receiving the Spirit from falling and injuring themselves. But on January 5, 2010, the pastor, quote, gave the Spirit, end quote, without the assistance of anyone. And as one member received the Spirit, she fell backwards, knocking several other members into the plaintiff, who fell to the ground with several people falling on top of her. Jones allegedly lost consciousness and suffered injuries to her head, neck, back, and buttocks. She is seeking at least $50,000 in damages. Have you ever heard of something like that before? Okay. Believe it or not, lawsuits arising out of that sort of situation in the church. I always felt that the best defense was act of God, but I haven't seen that as a defense in any of these. Well, so she's a bystander, and she sues because of somebody toppling into her after they fell under the Spirit. Here's an Oregon case, and this one's a little different because this is one of the catchers. One of the catchers is filing a lawsuit. The latest swoon and fall case against the church comes with a novel twist. The plaintiff was allegedly injured when another member of an Oregon church who was slain in the Spirit fell on her. The lawsuit filed last week against the Portland Omnuri Church in Beaverton involves a congregant who was allegedly acting as a catcher when she suffered a fractured spinal vertebra. Shin Lim Kim alleges the leader of a church service on August 11, 2008, asked her to catch another congregant who was going to be blessed or who would be slain in the Spirit. The leader then laid hands on Hoon Ju Yoon, who fell backwards and began flailing, falling on and injuring plaintiff. The church was negligent, the complaint says, in not providing the multiple catchers, failing to discuss safe catching strategy with congregants, selecting Kim, a small and not particularly strong person, as a catcher, and failing to instruct congregants on the correct procedure to fall so that they would not injure themselves and injure the person assisting or catching them. She filed the lawsuit claiming she was damaged in the amount of $125,000 for her pain and suffering, and this one actually went to a jury trial up in Multnomah County. And Oregon, I have to say, I commend you. In March 2011, a jury returned a 9-3 defense verdict, finding that the church was not liable for Kim's injuries. Well, you know, they may have won the lawsuit, they won the battle, but they've lost the war, because all of that focus on that sort of incident ruins the reputation of the church, ruins the focus of the pastor, and there's simply nothing good that comes out of that sort of situation. Well, one more, if you don't mind, and this one now is the swoony herself who was injured, okay? And I have a personal connection to this one because this is called DADD, D-A-D-D, versus Mount Hope Church and David R. Williams, who is the pastor of that church. And I was shocked when I saw this lawsuit in the Michigan Supreme Court reports, because my dad was the pastor of that church for a number of years, and David Williams was mentored by my dad, and then became the senior pastor. And unfortunately, I think either David forgot some good advice from my dad, or my dad forgot to tell him that he should be careful what he says in the pulpit, because this is what happened. Defendant Mount Hope Church is an Assembly of God church, and I'm reading, by the way, from the Michigan Supreme Court case, the reported case. In the Lansing area, defendant David Williams is the church's pastor. In accordance with one of the church's core religious practices, it is customary at services and other gatherings for the pastor to call congregants to the altar to be prayed over. Sometimes these who are prayed over fall to the ground, a phenomenon referred to as being slain in the Spirit. While there are ushers present at the altar to catch people, church members believe that a person who is slain in the Holy Spirit will not be hurt while engaged in the practice. On July 18, 2002, plaintiff, who was at the time an active member of the church, was slain in the Spirit and fell backward, injuring her head on the floor. A few months after the fall, when their medical bills began to accumulate, she inquired of the church whether it would pay for the bills relating to the fall. Plaintiff was told that the church's insurance would pay only $5,000. Let me pause right there. Every one of your policies that you have, your liability policies, should include a no-fault medical clause. Doesn't matter why. As long as somebody is injured on your premises, they are entitled to compensation as to medical bills. $5,000 is not enough. $5,000 is sucked up when the person goes to the emergency room. Okay? So you should be aware as to what your policy limits are on the premises medical coverage. Okay. Plaintiff then quit the church and filed a complaint seeking damages for negligence and gross negligence against the church and the minister. After the complaint was filed, defendant Williams, he's the pastor, senior pastor, spoke about plaintiff's lawsuit from the pulpit for about 4 minutes at a, quote, leadership rally attended by church leaders, workers, and members. At this event, defendant aggressively questioned the merits of the lawsuit, as well as plaintiff's moral and spiritual character for bringing the legal action against her church, specifically stating that he thought that the plaintiff had apparently renounced her faith for mammon. About 3 months later, defendant sent a letter to, Williams, sent a letter to members of the 120 Prayer Group, a 50-member church organization to whom he sent regular correspondence asking for their prayers on matters of concern to the church. One of the primary requirements of this group was confidentiality. In his letter, defendant again forcefully denounced the lawsuit and plaintiff's moral and spiritual character, referring to her as the accuser and plaintiff, asserting that he believed that she would be prosecuted for insurance fraud. That last part is what killed him, claiming that this was insurance fraud, and he said it in a public setting. And we're going to come to that in a minute, but that's one of the dangers currently that can bring litigation in the form of invasion of privacy and defamation. The judge that went to trial, jury trial in Michigan. The judgment reflected a verdict awarding plaintiff a total of, anybody want to guess? How much? Huh? No? Well, you're not quite that bad. $317,000 for that claim, and she was the person who was slain in the Spirit. Okay? So we have had now in this, what I think, extreme litigation against pastors and churches, everybody who is involved in that process except the pastor, who is the one who's laying on of hands, the bystander, the catcher, and the swooney herself. Well, let's look at, this isn't rocket science, folks. And if this is a part of your church services, it may be, it may not be, just use your common sense here to prevent this from happening. You always have to have catchers. Without exception, you have to have catchers. You have to train your catchers on how to catch people and prevent them from falling and being injured. And you have to use able-bodied catchers. Don't use an 80-pound woman to catch a 220-pound man. Okay? You got to make certain they're able-bodied. And finally, you got to make sure your liability policy includes that no-fault medical coverage that we talked about. Yes, sir?
Define no fault.
It doesn't matter how it was caused, whether the church was at fault, whether the person injured was at fault, it doesn't matter. As long as there was an accident, an injury, and medical bills, that's all that counts. You don't have to, the insurance company can't say, well, you know, you caused this yourself, you can't have it. Any injury, no fault, doesn't matter what was the cause, okay?
What would adequate coverage be? 50, 100, 150,000?
Oh, I'd say 50. Yeah. Yes.
So our church doesn't have our own facility. We rent from a theater. So if somebody gets hurt in the theater, who's liable if they're there for church?
Good question. And the question I have to ask is, my guess is that you are required to sign an indemnity agreement with the theater before it was rented. Do you know if you did that or not?
No.
Okay.
But it's like in the parking lot of the theater. Like we're liable for everything that happens on the
Yeah. If typically when you rent a theater or a large building for your services, as part of that lease agreement, you're going to be required to sign an indemnity agreement, which means that you are at fault for everything that occurs there, even though it might be the theater's fault. It may be a bad design, or it may be the lights have gone out and haven't been replaced. But most of the time, there's an indemnity agreement. Otherwise, it's whoever's at fault. If it's a design issue, it's not yours. It's the theater's. Yes, sir.
That only applies if they're using the facility at the time that their services were
Correct. Correct. Yeah. It's not a blanket. Yes.
Speaking of parking lots, a neighboring church had a gentleman who was a known sex offender pick up a young lady who was not quite bright and ended up raping her. How liable is the church for that?
They're not. Okay. Unless you knew or had reason to know
the church knew
that he was there.
The church knew.
I'm sorry?
The church didn't.
The church knew?
He had repented several times, so they thought he was okay.
Yeah. That is
that's where we get to the stickies.
That is an issue that is becoming more prevalent all the time. Because we as churches and ministries operate on trust and forgiveness and that sort of thing. But let me tell you something. If you have a one-time sex offender, you have to probably ask him not to attend. And it's tough to do. But, you know, there's no question in my mind that a 4-time sex offender, is that what you said?
No, I said he had known sexual offense. I had a sex offender come to my church, and I said, "You're welcome to come now. Correct me, and maybe this I shouldn't have done." I said, "You're welcome to come, but you need to know you will be watched."
Yes, and
you will not go into the children's
correct,
room. You will not go
correct. And under no circumstances would you ever allow that person to become a youth leader or a Sunday school teacher or anything like that. No way. And I think you handled it correctly.
Well, the neighboring pastor I had called because he was a young man, and I knew the history of this gentleman, and I called him and I said, "Are you aware?" Just wanted to make you aware, because this young lady goes from church to church to church. So she's been to my church, she's been to a couple other churches in town, and we don't let her out the door without watching it. I mean, our same staff watches her like a hawk, because she just isn't real right.
Okay. Well, here's the basis for liability. It's a very simple thing. It's simply called tort liability, and it's a violation of a duty imposed by law or a claimed wrongful conduct resulting in damage. Let me give you a simple example. You're driving down the street and you are reading, or your phone, your smartphone, and you're texting your wife telling her you're on your way home for dinner. Okay? And there's a stop sign, and you run below the stop sign, you hit the car broadside, you injure the person. You have violated a duty. The duty was to stop at the stop sign, and you didn't do it, and it resulted in damages. That's the principle, and it's simply called negligence. And if you're negligent, you are liable. It's as simple as that. And negligence is simply the failure to exercise ordinary care. It's the doing of something that a reasonably careful person would not do under the same or similar circumstances. It's simply a reasonable man test. What would a reasonable man do under same or similar circumstances? It's the failure to exercise ordinary care. Okay? There are two ways a church can be liable or negligent. One is for its own negligent conduct. The church itself, as an entity, does something which is negligent. Secondly, for the negligent conduct of others, which is called vicarious liability, and this is where all the action is, frankly. If one of your employees acts negligently and hurts somebody, the church is liable, as long as that employee was acting within the course and scope of his employment. Okay? And even more of a problem are what we call agents. That's who you would call a volunteer. You want as many volunteers in the church as you can. We need volunteers. But if one of those volunteers is carrying out an act or an action for the benefit of the church, you're liable. The church is liable. The pastor will be sued. The church will be sued. Possibly the network will be sued. And it's even gone as far as Springfield gets sued because some lawyer wants to make sure he's covered all the bases. And so good example of that is a case that occurred in Wisconsin, Milwaukee, where a Catholic priest asked a volunteer to take a statue of the Virgin Mary over to another parishioner's house so she could have it and use it. So she puts it in her car, she drives, she's in an accident, there are serious injuries, she gets sued, the priest gets sued, the church gets sued, the diocese gets sued, everybody gets sued because of the legal principle of vicarious liability. As long as somebody is acting on your behalf at the time and is negligent, then the church and the pastors are going to be negligent as well. Okay. Yes?
So say we have signs on the roads that we have to set out and pick up, and we send somebody out in their car to pick up those signs, and they get in an accident,
Mm-hmm.
we're liable.
And it's that person's fault, right? Okay. Mm-hmm.
Where the church is liable, not that person's car insurance.
No, that person is liable. That person gets sued, and typically that person has low limits, minimal limits, insurance limits. In Washington, it's $25,000. The insurance company tenders that money, and they then go after the church. But under your scenario, the church would be responsible as well as the individual, him or herself. Okay. Yes?
How would that affect the difference between a church bus that goes out and picks up children or people for the church versus private individuals in the church that brings people to church when they need to go?
As obviously the bus situation, the church is liable. Okay, in that circumstance, the question, the hinge pin there would be: did the church ask that person to go pick up that person to bring her to church, or is this person doing it on her own? If it's the former, there will probably be liability. If it's the latter, no.
So the pastor gets up and says, I need a volunteer to pick up. That's the same problem as asking a specific person.
Yes. Yeah.
Oh, dear.
Well, and we're going to get to it in a minute if we have time here, but automobile accidents involving churches is a huge, huge liability issue. It really is. Okay. Now, let's go. I'm going to skip this part. Oh, by the way, bystander, did your lawyer give you bad advice, client? No, I paid for it. Let's look at defamation just a minute. We heard about the Mount Hope case, and what is defamation? Okay, and this happens regularly, where somebody overstates in a public meeting of some kind, inflames somebody, and a suit comes. An oral defamation is a slander. A written one is called libel. Statement about someone which is 1, false, 2, published to a third person, and 3, which damages one's reputation. Let me give you, you saw the Mount Hope case where the pastor accused her of insurance fraud. Okay, that's defamation. It was found, he didn't do any investigation at all. He didn't know whether it was really fraud or not. He just thought it was. And it was false, found to be false. It was published publicly, and it damaged somebody's reputation. And here are 2 other examples. A pastor publicly charged a member of the congregation with having a, quote, vile spirit, quote, one of Satan's choicest tools, end quote. I don't think the pastor liked that person very well. And a jury trial found that to be defamatory. Okay, another example. The pastor became suspicious that a church volunteer and an associate pastor were having an affair. Relayed suspicions to several non-leaders. Mistake number 1. Okay? You do not disclose those kinds of statements to anybody who does not have the need to know. Okay? And you have to be very careful, particularly in that kind of situation, as to whom you disclose your suspicion. Well, it was found out, and he relayed suspicions to several non-leaders. It was found out that those state suspicions were unfounded, but in the meantime, the volunteer was dismissed, left the church, sued, and won $337,000 in a 2-week trial. Yes?
This is a reverse, but just today on CBS News, Seattle, pastor sues ex-church members for $500,000 for criticizing him online. Defamation.
Really? And that's in today's... Interesting. Well, you know what? That's tougher. It's tougher for a pastor who has been kicked out of his position or has volunteered. It's tougher for a pastor to make a claim like that than it is for others because of what we call the ecclesiastical immunity doctrine, and I've skipped that because we don't have time to cover that. But there is a narrow immunity. I can tell you that Oregon has the narrowest immunity probably in the country right now as a result of a recent case. But if it involves purely spiritual issues or doctrinal issues, disputes, and nothing else, and it involves only member versus member and not a third party or pastor versus the church, it is tough to win those lawsuits by the pastor because of the immunity. And I don't know it'd be interesting to see what
turns out, but to me the key phrase was online. And just
interesting.
About Facebook today, the social media.
Wow. You can see how fast it takes off, can't you? Yeah, okay.
We're calling the pastor controlling and the church the cult. That's the white suit.
Controlling and code.
It was a cult.
The pastor called the church that?
No, they called the pastor controlling.
Okay.
They called the church cult. These are people who had eventually left the church.
Okay, interesting. Wow. Well, here's how you avoid defamation. And again, it's not rocket science. You always speak the truth. You always speak in love. You speak well of others. If a genuine issue arises, avoid public dissemination. Keep private, need-to-know communications only. Keep in the context of disciplinary proceedings, because that's where the immunity is. Be accurate. Know your facts before you make the statement, even to the people who have a right to know. You have to know the facts before you make your accusation or your suspicion. Follow the rules and guidelines, if you have them, your bylaws for the church. And if you're wrong, just frankly retract it immediately. Churches get in trouble all the time for hiding or delaying what they know to be has occurred to be wrong. Happens all the time. Okay, here's another one. Invasion of privacy. This is also a major issue in litigation these days, where someone talks about them and invades their right of privacy, which is a legal principle that people have right of privacy in this country. Let me give you an example. In his column in the church's monthly newsletter, Pastor Edwards wrote the following, okay? I was personally deeply blessed this last week after speaking with one of our newest members about his experience in coming to know Christ. He admits to a long history of drug abuse and sexual promiscuity prior to coming to the Lord and becoming involved here at First Church. While he regrets many personal decisions that he now believes were foolish and destructive, he also now sees God's constant direction in his life, even during his wayward years. We rejoice that he is now with us here at First Church, and that he and others like him are willing to share their wisdom and faith with us, as well as their personal trials and failures during years without the Lord. This newsletter was mailed to the congregation's 550 members. It did not explicitly state that the member to which Edwards was referring was Bob, who was a new attorney in town. Oh, boy. And a new member of the church. His readers could easily deduce it was Bob. You know, he didn't mention his name at all. Didn't mention his name at all. Didn't say who it was. But since he was the only new member of the church in the last 8 months, and since the 3 previous new members all had been women, hello. Again, didn't take a rocket science to figure out to those people who got that message that this was Bob. Well, Bob had made those statements believing they would be kept confidential. That was in a meeting in the pastor's office where confidential communications occur all the time, and he believed that would be the case. And he didn't like it that everybody knew about his past, and pastor even said some things that he thought were inaccurate and not true, and so guess what he does? He leaves the church and he sues. I wish I could tell you the result of that, and I don't know. Probably the insurance company settled it, confidential agreements, and so we don't know what happened as a result of that. There's an Oregon case on invasion of privacy. An appeals court upheld a jury verdict for plaintiffs for defamation and invasion of privacy against the pastor for placing the plaintiffs in a false light. A member's children were injured in a motor vehicle accident with another church member. See what happened? You got an accident, and both drivers are members of the same church. Okay? And there were children in one of the cars, and they were all injured. The pastor informed the board and congregation that plaintiffs were exaggerating and faking injuries in order to obtain a larger settlement. No investigation of the facts to support that allegation had occurred. Pastor got sued, the church got sued, and the children recovered $253,000. Okay, that's the Oregon. Okay. Well, we're running out of time here, so this is probably how to avoid them, how to avoid invasion of privacy. Again, just use your common sense. Keep private facts private, especially in counseling. We're going to get to counseling in a minute. That's another big one. But always obtain permission to share personal facts. Always. I'd suggest you do it in writing. If you're going to share somebody's personal life, you better get a consent and a waiver to do it. If permission is granted, make certain you are accurate. Anticipate and avoid conflicts of interest, and as we said, obtain consent in advance. Well, when you go to court, you are putting your fate in the hands of 12 people who weren't smart enough to get out of jury duty. Let's look at counseling claims for a minute. In general, churches can be held liable for negligent counseling, for sexual misconduct in counseling, negligent selection, retention, and supervision of counselors, failure to report child abuse when required. That's a big one. We're going to talk about that more in a minute. And breach of confidentiality or fiduciary relationship. That's another very common basis for a claim that there has been a breach of confidentiality. When the pastor has heard something, or the youth leader has had a session with one of his kids, and there has been, if you will, a confession, and it was meant to be confidential, and the youth leader just happens to mention to his wife, blah, 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 and off it goes. Okay? That's how that gets started. Well, other types of counseling claims. If the church hires or uses licensed therapists or non-clergy licensed counselors, the church can be liable for their negligence. We've got all types of counseling that goes on in churches, and it's a very important part, in my view, of the church's ministry to the body of Christ there. You will have pastoral counseling. You will have associate pastor counseling. You will have lay leaders who are counseling. You may have lay counselors who are counseling. You may have a list of preferred outside professionals, psychologists, Christian counselors, whatever, that you would refer to under certain circumstances. But I can tell you that in every one of those circumstances, if there is negligent counseling or if there's sexual misconduct as a result of the counseling, the church, is liable. Okay? Simply put. No, okay, just stretching. Okay. Yes.
So lay counselors.
Yes.
If they're not licensed.
Okay, and let me suggest something to you, that you should always, if you're using lay counselors, you should always use Well, let's see. It should come up here pretty soon, or maybe I went by it. You should use a consent form in advance that is read by the counselee and signed by the counselee that clearly states that the person is a lay counselor and not a professional, that you're using biblical and scriptural-based principles rather than secular basis for the counseling, and that you talk about confidentiality in that, and that should be always prepared, signed by the counselee. Let me tell you that there are excellent forms out there for this sort of thing, and some of those forms are found on the websites of the insurers who insure churches. Let me give you two of them. They've got forms you can download for all kinds of different things that you may be interested in. Two insurance companies do it I'm aware of. Guide, G-U-I-D-E, Guide 1 Insurance Company is one of those, and Brotherhood Mutual is another one, and you may already be insured by one of those. I'd suggest a call to your agent if you're looking for something special and he ought to get it for you. Just go to their website and look at their forms, and they have all kinds of forms, and among them is a very good consent form that you're talking about.
So if we refer to, like, my husband and I do counseling, so we refer people out.
Yes.
To, I don't remember the name off the top of my head, to whoever the network uses.
Okay.
Now, if they go there because we refer them and negligence happens, they can come back and sue us.
Yes. 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 And guess what? They can also sue the network. It doesn't stop. It doesn't stop. Okay. Yes.
So you were talking about licensed counselors or therapists. So then, I am an ordained minister, but I'm not a licensed counselor.
Right. And you. And that needs to be if you are in counseling, quote unquote, that needs to be disclosed to your person. Yes.
We have consent forms that say we do anesthetic counseling only.
Yes.
And we have to sign it.
Yes. Yeah, that's good.
So what you're talking about is a full disclosure of the counselor's abilities or
their limitations. Yeah. Because they are not licensed, they are not professionals, they are lay folks, and they are working on the basis of biblical, rather than they don't diagnose, never diagnose.
You need to have a signed by the counselee in your files.
Yes, you do. They understand that. Yes. Yes, sir.
Mutual has a whole packet on starting a counseling ministry and a lay counseling.
Good. Yes. Yes. Good. Is it available on the website?
I'm not sure. I've always got a hard copy.
Okay.
They've got many forms on their website, a lot of resources.
Yes.
Brotherhood, I think that's
Yes.
I don't know if you just call, they'll glad to send it to you.
Okay. Yes. Good point. Thank you. Well, let's jump ahead here. And, let's run through this very quickly. Reducing the risk in counseling. Screen carefully. If you're going to have people counseling as part of your ministry, particularly lay people counseling, you need to screen them. Absolutely. They should be screened carefully before they start. You should have a training program for them so they know how to do what they do and what their limitations are. You need to have careful supervision over them. You need to be thinking about the third person rule. And the third person rule is if a male is counseling a female, you may want to always consider having another female in the room. Third person. Women counsel women. That's better yet, if you have that capability. Careful physical locations. You need to be careful about where that counseling is occurring, and that area is open and available for others to observe if necessary. You need to limit your session times. You don't do 7:30 at night. You're the only two people in the building counseling, a man counselor and a female counselee, particularly. Avoid labels. If you are lay counselors in the church, you avoid labels such as therapist and counselor, and use terms such as minister and helper. Use those terms. That'll keep you out of trouble, because if you hold yourself out as a psychologist or as a quote-unquote licensed counselor, if you hold yourself out, you will be held to that standard in the courtroom. Okay? Use a written signed disclosure statement. We've already talked about that. Require form completion by the counselor at the end of every session. They should fill out a form as to what went on and what was discussed and what the plan was. And you can use the SOAP note directive and that's a good way to do it. And always carry liability insurance that covers all pastoral and lay counseling activities. A lot of insurance policies expressly exclude counseling activities. So if you're doing any counseling, lay counseling particularly, you need to look at your policy to make certain that's covered. You may have to, you may have to pay more, but you'll get an amendment or an endorsement to your policy. Just make certain that your policy, your insurance coverage includes counseling by all pastoral and lay folks. And obviously you avoid secular-based counseling therapy. Let's look for a moment, because we're running short of time here, on child abuse reporting requirements in the state of Oregon. Every state has different requirements for child abuse reporting. The state of Washington is dramatically different than the adjoining state of Oregon. But if your ministry is in Oregon, let me suggest to you that child abuse reporting, the failure to report when you should have, is going to get you in big trouble. Okay? Let's look at the requirements briefly. And by the way, this ORS is Oregon Revised Statutes, ORS 419B.005. If you want to read that statute in its entirety, just go online, Google Oregon statutes, and then insert this citation, and it'll take you right to that statute. Okay. Here, let's walk through it. Who is considered under the statute to be a child? Because this is a child abuse reporting. The statute says anyone under the age of 18. So if the person is under the age of 18, this statute applies. What is abuse? This is a child abuse reporting statute. What is abuse? Any assault or physical injury caused by another by other than accidental means. That is as broad as you can get it in the state of Oregon. You know what? An assault legally is simply an uninvited touching. Okay? Yeah, well, we'll get down to F in a minute here. It may or may not. But any assault or physical injury caused by other than accidental means, very broad. Any mental injury, which is observable and includes substantial impairment to the child's mental and psychological ability to function caused by cruelty. I mean, that's pretty detailed, but even mental injury in the state of Oregon can be child abuse. Obviously, rape, sexual abuse, i.e. any type of sexual contact, any type of sexual contact is child abuse in Oregon. Sexual exploitation, obviously. Then we come to F. Does not include reasonable discipline unless it results in one of the above. That may be spanking. Okay? So they give you a little out there. Okay, now this is real small print. I don't know why I got it this small. What is the test or threshold for reporting? When do you have to report? what has come to your attention. When, quote, any public or private official has, quote unquote, reasonable cause to believe that abuse has occurred to a child with whom you have contact or from contact with the abuser. Okay, let's stop right there. With whom you have contact, the victim, or from contact with the abuser. Okay, so you have two-pronged reporting requirements there. It may come from the abuser, it may come from the abused. All right? Well, who is any public or private official? Well, bad news. It includes, quote unquote, member of the clergy. All right? And that means any level of license and may include lay pastors. So if you have lay pastors who are undertaking counseling functions, there is a requirement there to report. So any member of the clergy comes within the statute. School employee, if you have a school as part of your ministry, it doesn't specify as to what kind of employee, whether it's the principal, whether it's the janitor. Okay? So any school employee has a requirement to report. If you have a daycare as part of your ministry, that's also included here. Licensed child care agency. If you are, or if you have counseling as a licensed professional counselor, a licensed marriage and family therapist, a psychologist, et cetera, et cetera. So this is very broad as well. Member of the clergy pretty much covers everybody. What is reasonable cause? Yeah, you need reasonable cause to report. It's a belief sufficiently strong to warrant a reasonable person to believe it to be true. That's mishmash, legalese. That's hard to understand. It simply means that if a reasonable person would believe that child abuse has occurred, then you have an obligation to report it. Okay? It's again the reasonable man test. If you have reasonable grounds to believe that it has occurred, then you must report it. How soon must you report it? Immediately. There's no delay in here. What are the consequences of not reporting when you should? Well, it's a criminal violation, and you are subject to civil liability. Can you be sued for reporting? Okay, you report, and let's say there never was one. They investigated it, Child Protective Services investigated and decided there wasn't any abuse. Can you get sued for a false report where you have really defamed somebody? Okay? Because you've accused somebody of child abuse. If you've reported in good faith, the statute gives you full immunity. So you're protected, even if you're wrong. To whom do you report? You report to the local office of the Department of Human Services or to a law enforcement agency within the county. You can report it by phone or in person. Okay? Let me ask one question here. How many of you have ever reported child abuse? Okay. And no adverse consequences as a result. Good. Okay, good. Now, here's the elephant in the room. Big elephant in the room. There's an exception to all of this reporting. You cannot report except that a member of the clergy is not required to report such information communicated by a person if the communication is privileged. If you obtain that information in the course of a confidential meeting with either the abused or the abuser, if that comes to you in a confidential setting, and the clergy penitent privilege attaches, there is, as you all know, when you are with a person and there are certain statements made and they are deemed to be confidential and you cannot disclose it in general. That is the clergy penitent privilege in the state of Oregon. And if this information comes to you through the clergy penitent privilege situation, in a confidential situation, you cannot breach the privilege. The privilege wins here over the other terms of the statute. Okay? And here's the actual privilege, the statute in the state of Oregon. A member of the clergy may not be examined as to any confidential communication made to the member of the clergy and the member's professional character unless consent to the disclosure of the confidential communication is given by the person who made the communication. That's the basic statute in the state of Oregon. It's privileged. You cannot disclose it. Okay? Now, in order to have that to occur, to apply, it's got to be, one, a communication. Two, it's got to be made to a, quote, member of the clergy, which means a minister who is authorized or accustomed to hearing confidential communications. That can be a lay minister if that person acts in that capacity and is acting in a professional capacity. Okay? Well, a convict was sentenced to the electric chair, called his lawyer for some advice. The lawyer replied, "Don't sit down." Okay. We are out of time. Okay? We haven't covered premises liability. We haven't covered activity liability. But let me give you one more little. Okay, here's my final comment. Any last words, the guys on the gallows with a rope around his neck? My lawyer said something about a loophole. You're wearing it. Okay. Thank you for your time and attention. You've got all of the slides for premises liability and activity liability. You can go through them at your leisure if you want to. It's pretty straightforward stuff. Okay. Let me give you a phone number. You can call me anytime. I'm not licensed to practice in the state of Oregon, so I'm safe here. Okay? I'm licensed to practice in the state of Washington. All right? But I'd be happy to point you in the right direction if I can, or answer any questions. If you don't know who to call, that's often the case with the people who don't have an attorney that they regularly use. Besides that, if you call him, he charges by the minute and by the word, and so your bill jumps up real quick. So my number, it's my home number because I have recently retired. I no longer have an office, is 425-814-1716. I'd be happy to answer questions there anytime you need it. Thank you very much.
Thank you for listening to the 2012 Summit Podcast. For more information on the Oregon Ministry Network and our events, please visit our website at oregonag.org.